Dr. Singhvi, welcome to our panel today. We are also celebrating 75 years of the Constitution. But in Parliament, there have been a lot of debates on a lot of issues where lawyers like you have a vital role to play. For instance, we've had the Places of Worship Act that is really doing the rounds today. We've had the Supreme Court also pass a landmark judgment on it. So what is your take on this?
Thank you, Priya. Normally get paid to speak before judges. This time the judge has to keep silent and I have to be able to. Thank you for a very generous introduction. Well, it's interesting you talk about the Place of Worship Act because I appeared just yesterday as one of the two lead counsel in that batch, and without encroaching on the sub judice nature of the matter, I think an excellent holding order has been passed by the Supreme Court just yesterday, and we appear at 3:30, 3:45. It has two parts, which is why it's excellent. It prevents further suits being registered till they hear the whole matter. And they can be filed, but they are non-starters. And for the existing matters, it prevents any effective, the exact words are effective, final or interim orders being passed in the existing suits. Now, why do I say it's important? First and foremost, while the matter is pending, as one of the judges put it yesterday, there cannot be a race between the apex court and the courts subordinate across the length and breadth of India, where suits are being filed almost like rabbits. Every day we find a new suit coming up in a different part of the country. The Supreme Court will decide it. The Supreme Court will hold one way or the other. But certainly on the interim, on the balance of convenience, etc., it is indisputable, but there must be a quietus, a stability, and no upheavals while the Supreme Court is seized of the matter. That is the basis of this order. It's not any final order. Now, if you ask me the larger question about my own views on the Act, I have no hesitation, and I don't mean to impinge on the Supreme Court. That's only an interim order. We'll be arguing it finally, and I don't know which way it will go. But I have no doubt that a well-considered legislative decision was taken way back to draw a line. You know, nobody is saying that the line is right. All lines are arbitrary. And I approach it from a different viewpoint. I have no doubt that any number of monuments and buildings and places of worship in India lie on top of diverse religious structures. I am a Jain, you are a Buddhist. There are many Jain and Buddhist structures over which other structures stand. And so also Hindu structures. The question is very simple: how far will you go? Where will you stop? At the Qutub Minar? At the Taj Mahal? You already invoked Ajmer Sharif. So, as Gandhiji said, an eye for an eye will do nothing but make everybody in this room blind. So you need to draw a line. The Act has drawn a line for us. And I don't think there is any value in opening it. Last point. Unfortunately, the courts below, till yesterday, and I'm glad the Supreme Court is crystal clear now, has had a very weird nuance in my understanding. The nuance is that you are prohibited from going to dinner by a law of Parliament. Parliament says, I cannot go to dinner in this ballroom. But yet you are entitled to examine which kind of dress I must wear for dinner. That is apparently the basis of the Supreme Court not acting earlier and not stopping these suits, something which the court rightly did yesterday. So the argument was that, look, while the structures can't be changed, why can't you have surveys to find out the nature of the structure? If the end result is predetermined by an act of Parliament, now more than 30 years old, then what's the point, at least till you finally decide the validity of the Act, to keep on inquiring that while we can't touch the structure of the Act, let's find out the nature by surveys. It's exactly like my dinner analogy, although it might sound facetious.
But the petitioners are also questioning the validity of the 90